before my birth, my father had already naturalized as a U.S. citizen. And since I was born in the United States to a mother who was also a citizen, my status was unquestioned. Until the current administration, such circumstances guaranteed automatic citizenship, a reality shared by many children of immigrants. Historically, the American Immigration Council defines birthright citizenship as the automatic granting of legal status to children at birth, either through ancestry or birthplace. For over a century, the 1898 Supreme Court precedent in the United States v. Wong Kim Ark solidified that anyone born on U.S. soil is a citizen regardless of their parents' status. However, the concept of birthright citizenship is now at the center of a national debate. This status also extends to individuals born in the United States whose mothers were either undocumented or present on a temporary legal basis. These citizens have been a focal point of the current administration's policies since its inception. Anti-immigration factions have long pushed to restrict this right, particularly for children of undocumented parents. While former President Trump considered such a move in 2019, he did not take action until his second inauguration on January 20th, 2025, when he issued an executive order to deny birthright citizenship to these children. The controversy has intensified due to Executive Order 14160, protecting the meaning and value of American citizenship. This order attempts to end birthright citizenship for children born in the United States on or after February 19, 2025, to parents who lack permanent legal status or are undocumented. The order was immediately met with legal challenges from groups like the ACLU, while multiple federal district courts in Maryland, Washington, and Massachusetts issued nationwide blocks on its enforcement. The administration has fought to limit the power of single judges to issue such universal injunctions. Consequently, the constitutionality of the order is now being debated before the Supreme Court. If you follow this channel regularly, you will likely recall my July 7th, 2025 video regarding the executive order. In the time since that upload, there has been a marked rise in the lawless nature of anti-immigration enforcement tactics. We are now witnessing extreme levels of violence that specifically target individuals expressing even the slightest opposition to these enforcement strategies. The central objective of this legal challenge is to reinterpret the 14th Amendment's phrase, subject to the jurisdiction. The administration argues that the Citizenship Clause should only grant status at birth if at least one parent is already a citizen or a lawful permanent resident. This reinterpretation seeks to shift the traditional understanding of jus soli that has prevailed for over 125 years. If the Supreme Court rules in favor of the administration, it could fundamentally alter the requirements for citizenship and empower the executive branch to carry out its agenda with fewer judicial obstacles. The terminology subject to the jurisdiction entails being bound by the legal sovereignty, authority, and statutes of a particular government or judicial body. Within the framework of the 14th Amendment's Citizenship Clause, this signifies a total submission to U.S. political jurisdiction and a direct allegiance to the nation, as opposed to being governed by a foreign power. Challenging this specific provision of the 14th Amendment may result in unforeseen repercussions. For instance, an individual traveling abroad who commits an offense is held accountable to the laws of that host nation rather than their home country. By disputing the legitimacy of this phrase, there is a risk of dismantling the U.S. government's legal authority over all non-citizens within its borders. Federal entities, specifically the Social Security Administration and the State Department, would be compelled to withhold Social Security cards and passports from children impacted by this order. While this would not apply to anyone born prior to February 19, 2025, the implications for future generations are significant. The validation of this executive order, which entered hearings on April 1st, 2026, poses a threat to the status of over 250,000 infants born in the United States annually. Furthermore, there is a risk that the scope of this order could be expanded to encompass all generations of American residents. The actual consequences of such a shift could theoretically jeopardize the status of any U.S. citizen, aside from indigenous peoples. The vast majority of American residents descend from ancestors who may have held permanent legal residency at some point. Taking to its logical conclusion, this scrutiny could extend as far back as the arrival of the Mayflower. Conversely, this shift threatens to divest those suspected of being non-citizens or undocumented of their constitutional protections. By asserting that such individuals fall outside of the U.S. government's jurisdiction, the state effectively removes the guarantee of their fundamental rights. While I generally refrain from hyperbole, the current situation demands our attention. This administration has embraced a remarkably rigid and uncompromising position regarding immigration. Stephen Miller, the White House Deputy Chief of Staff, recently claimed via Twitter that U.S. asylum applications are universally fake. He further contended that migrants exploit the right to birthright citizenship to facilitate what he termed industrial-scale remittance farming. Miller added when he persisted in this online vitriol, which can only be characterized as blatant prejudice, by asserting that immigrants pursue U.S. welfare programs and that U.S.-born children serve as a means of financial gain for relatives in other countries. He further argued that U.S. welfare remittances provide the backbone for entire foreign economies, explicitly connecting his rhetoric to the enduring opposition to birthright citizenship laws. These remarks are just the latest in a series of statements by Miller framing immigration as both an economic and legal issue tied to citizenship. Acting as the primary designer of the Trump administration's immigration strategy, Miller serves as its official voice. His rhetoric is mirrored in policies that provide funding to private prison corporations, entities responsible for detaining and, in some instances, losing track of arrested immigrants, and even some U.S. citizens. Furthermore, 2025 financial disclosures reveal that Stephen Miller maintains a substantial personal financial interest in Palantir Technologies. While Palantir does not operate private prisons directly, the data analytics firm provides mission-critical services to U.S. immigration and customs enforcement by supplying the essential technology infrastructure for ICE's detention and deportation operations. Palantir serves as a key driver for the private prison industry. Disclosures from 2025 reveal that Miller holds between 100,000 and 250,000 in Palantir stock. This financial stake in a major government contractor has sparked significant ethical alarms, as Miller serves as a primary architect of detention policy. Experts have noted that he is nearly in violation of conflict of interest regulations. Furthermore, Miller's directive to scale up arrests to 3,000 daily directly benefits the bottom lines of private prison firms like Geo Group and Core Civic. These corporations are currently experiencing unprecedented demand as a result of the administration's current immigration strategies. The Supreme Court may appear dubious of the arguments presented, yet the majority of the bench maintains an allegiance to Trump. Consequently, a ruling in favor of the executive order remains a distinct possibility. Given that constitutional precedents are seldom overturned without a formal amendment or subsequent judicial reversal, the impact of such a decision would be lasting. Should the ruling favor Trump, we have the option to withhold our compliance. By boycotting businesses that fund Palantir, Core Civic, and Geo Group, we can exert economic pressure. Furthermore, we can demand that Congress enact laws to safeguard birthright citizenship from the for-profit presidents Donald Trump. Henry David Thoreau said, "If the machine of government is of a nature that it requires you to be the agent of injustice to another man, then I say, break the law." That's all for this week. Until next time, remember, silence is compliance. Your voice is vital. Stand up, speak out, strike back. They don't know what they started. If you appreciate this content, please like, share, and subscribe. For updates, ring the bell. Your support truly helps the channel.